Welcome to today's edition of the IntoTexas AI podcast. It's your look at AI news and trends impacting Texas. I'm your host, Shannon Belew. Let's get started. Today, we're going inside the legal system and taking a look at a recent Texas ruling about whether ChatGPT prompts used by a non attorney can be protected from discovery. Now, this is a topic that's been much debated, as well as just AI's broader impact on the court system and what should be allowed. And we have federal judges calling for clearer AI rules, while some attorneys have already faced serious sanctions for fake AI generated citations. We have judges themselves who are beginning to use AI to prepare for hearings. And we have legal aid organizations testing AI tools for access to justice. So, this episode is not just about one chat GPT ruling. It's about where AI belongs in a system that's built on trust. As of now, well, we know that AI is entering the legal system, but the legal system is responding with what seems to be a very clear message. You can use AI, but you are still responsible. The Texas point of view. Let's start with the most recent Texas ruling. In June, the Texas Business Court looked at a discovery dispute involving ChatGPT conversations. In this particular case, a business principal, so not a lawyer, had used ChatGPT to think through issues connected to the litigation. When that came up in discovery, the opposing side wanted access to those ChatGPT conversations. And the court largely said no. The court treated most of those conversations as protected work product. Okay. If you're not familiar with what that term means, in Texas, protected work product refers to legal materials, reports, and strategies created by or for an attorney in anticipation of litigation. Now, governed by Texas Rule of Civil Procedure, it essentially prevents those types of documents from being shared with the opposing side during the discovery process. Now, this is important, but we also need to be careful with what this latest ruling does and does not say. For example, the court did not say that GPT is the equivalent of a lawyer, and it did not say that conversations with ChatGPT are attorney client privilege. To be clear, it also did not say that every AI prompt connected to a legal matter is automatically protected. Instead, what the court seemed to say is that under the facts, again, of this specific case, a non lawyer's AI assisted legal preparation could fall under work product protection, which is a very different legal category from attorney client privilege. Now, attorney client privilege protects confidential communications between a client and lawyer for the purpose of getting legal advice. ChatGPT is not a lawyer, it does not create that attorney client relationship. So, work product is different. It can protect materials prepared and participate in anticipation of litigation. And under this Texas rule, that protection can apply to materials prepared by or for a party. So it gave the Texas court just some room to say, look, if a party is using ChatGPT as part of their own litigation preparation, then those conversations may be closer to private legal notes rather than something that the other side would automatically get to see. But there was still a boundary put around all of it. The court still required the party to disclose which discovery materials had been shared with ChatGPT. So the strategy conversation was mostly protected, but the fact that materials were uploaded or shared with the AI tool was not invisible. So I think that the takeaway is that this is not a green light to dump sensitive legal material into an AI tool like ChatGPT or Claude and just assume that everything is private. It's more like an early example of how courts may start drawing lines. So let's talk about that larger conversation. Okay, since this Texas ruling, the national conversation around AI and court filings has definitely continued to intensify. In fact, a U.S. magistrate judge has urged the federal judiciary to consider a nationwide rule requiring litigants to certify the accuracy of legal citations when generative AI is used in court filings. But there's still a lot of variation on how the AI topic is treated within the justice system. Some courts do have standing orders, some have local rules, and some do require disclosure. Some judges are still deciding what level of AI specific certification makes sense. And Texas is very much part of that kind of patchwork approach that's happening. The Southern District of Texas has warned attorneys and self represented litigants not to submit AI generated pleadings, motions, or any other papers unless they check the content for accuracy. Now, the Northern District of Texas adopted a rule requiring disclosure when a civil brief is prepared using generative AI. And the Eastern District of Texas has also moved in this direction with AI related rules. So I think maybe the message for now, AI is allowed, blind reliance is not. And, we're already seeing why courts care so much about this. In fact, in June, a federal judge in Mississippi actually disqualified all attorneys on both sides of a contract dispute after unverified AI generated legal research produced fabricated citations. Now, the lawyers involved were fined, and some were actually barred from practicing in that court for 2 years. Perhaps that may be a bit of a dramatic example, but it does reinforce, the similar themes that we're seeing. I think that the problem is not that someone used AI. The problem is that humans filed material that they did not verify. And this is where the Texas Business Court ruling fits into that broader picture. On one side, courts are recognizing that AI may be part of legal preparation. On the other side, courts are making clear that AI does not lower the standard for accuracy, candor, or professional responsibility. So, judging AI, again, let's be clear, it is not only lawyers using AI, judges are beginning to explore it too. In fact, there was a recent study that found a majority of surveyed federal judges had used at least one AI tool in their judicial work, though many said that it was used only occasionally and with caution. Now, there was a Texas federal judge, Xavier Rodriguez of the Western District of Texas, who has really become one of the more visible judicial voices in this conversation. He's been part of the national discussion about responsible AI use by judges, and he helped initiate a judicial AI consortium with other state and federal judges to share information about the risks, the use cases, and practical realities of AI in the courts. I think we're realizing that, if lawyers are using AI and litigants are using AI, legal aid organizations are using it, and then certainly if judges are using it, then, AI is no longer an issue that can be tabled or put on the sideline. We need to have rules, we need to have processes, we need to have an approach standardized in how we're going to use it in the justice system. I really think that it's similar to what we see in companies of all sizes today with AI, right? It's becoming part of our operating environment, and we have to understand how to put guardrails around it, how to develop those proper use cases, the governance that's required, and continued human oversight is always critical. So I think this is the same thing now that we're starting to see in the legal system as part of its operating environment. The takeaway here may be that while AI can help with timelines, summaries, research, drafts or hearing preparation, the decision for a ruling still and will always belong to the judge. And the accountability still belongs to the human. AI to the aid. Well, that brings us to one other Texas example that I think is pretty interesting: Lone Star Legal Aid. Now, this is a Houston based nonprofit law firm which has 11 offices serving clients across 76 counties. And according to one report that I saw, they say that they handle approximately 25,000 cases every year. Now, in late 2024, they received a technology initiative grant for an AI chatbot project. The project officially kicked off in December of that year. And since then, they have developed three AI powered chatbot tools that are in use or are being tested. Now, one is Navi, which is a public facing chatbot designed specifically to help people, the general public, right, understand common civil legal issues and get help identifying possible next steps from a legal perspective. The second tool is called Juris, and it is an internal legal research and knowledge support tool that's built with attorney vetted content. And then they created a third chatbot tool, which is again another internal tool designed to help staff with administrative functions, HR, IT, and just operational questions. Now, I think these are all great examples of how AI is being used for public access and education, as well as internal efficiency gains. And legal aid organizations in particular, I think, are stretched and just really resources are limited. And there are many people who do need help who may not qualify otherwise for assistance or can't find an attorney or don't even know whether their issue has legal standing in the first place. So if AI tools can support that legal aid staff so that they can spend, less time searching for internal information or doing administrative functions and spend more time helping people, helping the public as their intent is, all of that seems like a good use of AI. But, I think it continues to require guardrails. I said this before, and I will continue to emphasize how important that is. To me, the Lone Star Legal Aid example is not about unleashing a chatbot to practice law. It's about using attorney vetted content, careful design, and human oversight to make legal information easier to understand and to access. All right. As I wrap up today's episode, I'd like to emphasize that I am also not a lawyer or practicing law. So, while my personal point of view on this topic is that there are many positive opportunities to bring AI into our legal system, I do understand that there is a lot of at stake, right? It's serious issues, people's livelihoods, their lives are impacted with a lot of these rulings. And it's really important that we get this approach right, however we bring AI into the legal system. And again, I'll continue to emphasize this. As I stated, I just think it is so critical that we continue to require guardrails and continuous human oversight whenever we bring AI into our systems and our environments, like the legal system. I'll also share with you that I do have several friends who are practicing attorneys, and I know that there are very passionate points of view on the role of AI in the legal system. We've definitely had some great conversations about the pros and cons of this and what we might can expect in the future. So, on that note, I would also love to hear from all of you, any of you who are working in the courts today, whether you're an attorney or a court reporter or a judge, whatever your role in the system. I'd really love to hear your viewpoint on where you think AI does and doesn't belong in the justice system. And, what do you think is going to happen with AI as we move forward? So please leave me a message. Would love to hear your opinion. And that's it for me and for today's episode of the IntoTexas AI podcast. As always, I really appreciate your giving us your time to listen to our points of view and hear the latest news on how AI is impacting Texas. And if you would like to continue to get those insights, then I certainly invite you to continue listening or watching. And please share and would love to have you be a subscriber. So that's it for today's episode. I'm your host, Shannon Belew, and I'll see you next time.